2022.
I had no idea.
And she had a, what was your accident?
My daughter's over my case. I got hit by a semi truck. I don't know.
Was that your fiance was in an accident, right?
My fiance got hit by a truck, and then I got hit 4 years later by a semi truck in North Carolina in Charlotte.
Okay. Well, you haven't had that problem since then, up until now. I guess it's an odd question.
Okay, right away you can feel something is off here. This woman is clearly dealing with serious trauma, and the judge is trying to connect the dots, but it's coming out awkward. And this is where courtroom moments get uncomfortable fast. Trauma doesn't always sound organized, but it's still real. Question for you. Should courts be more patient when someone is clearly struggling to explain their situation?
For me to ask, but anyway. Good morning, ma'am.
Morning, Judge.
Mr. Swift?
You all right?
Yes, sir.
We're prepared to enter a plea. I think she's been approved for ILC, correct?
She's eligible for ILC.
Yeah. If you give me the document, I'll...
It's like...
Okay, so this part is actually huge. ILC means intervention in lieu of conviction. Basically, the court is saying, we'll give you treatment instead of a conviction. That's a major break. But notice the tone. The judge is joking around, everyone's laughing. Meanwhile, the defendant's life is literally on the line here. Would you feel comfortable in a courtroom like this? Or would it feel disrespectful?
He's holding a hostage just in case. You say yes, I'll give it to you.
What's the state? This is case of State of Ohio versus Alicia Bell, case 22CR39795. Ms. Bell was present with her attorney, Ben Swift. The state is represented by Brian Goodyear. We are here for a hearing on ILC. What's the state's position on ILC?
We have no objection, Your Honor.
Okay, Jenny Nicholson is representing the state. Ms. Bell, do you understand what treatment in lieu of conviction is?
Yes.
I want to go over, please speak up. I want to go over your constitutional rights. You do have a right to have a trial by a judge or jury of 12 people. Do you understand that?
Yes.
You have to answer.
Yes, sir.
Mm-hmm. You have a right to confront every witness who testifies against you at trial. Are you aware of that?
Yes, sir.
You have a right to have witnesses ordered to appear and testify at your request. Do you understand that? All right. Any dispute over that amount, Mr. Swift?
No.
Check, wasn't it?
No.
Yeah, it was a check.
Check.
So this sounds like a classic check alteration case. Basically, a check was meant for someone else, and the name got changed. Now here's the tricky part. Courts don't just care what happened, they care what you knew and what you intended. Was she the mastermind? Or was she being used by someone smarter? Because in fraud cases, that difference changes everything.
From a company that was written to someone else and somehow they altered the name of the payee and presented the check. Okay, so that amount is ordered. Anything else from the state?
No, Your Honor.
Anything else? Anything, Mr. Swift, on behalf of Ms. Bell?
Well, Judge, she is on Social Security due to an accident many years ago. However, she lives in the Columbus area, so we would ask that any supervision be, she be able to do whatever she needs to do up there.
Generally, that's what you'll do, right?
Yes, we can request it. It's up to Franklin County whether they...
You have to have substance use treatment for the cannabis use disorder. Is it thinking for a change or corrective thinking that you think would be appropriate here?
Your Honor, I think maybe corrective thinking would be a good order since Franklin County might do something different.
Okay, since they're supervising, they choose that?
Yes.
Okay. Anything else?
One thing, Your Honor, Ms. Bell has been using medical marijuana, so I think that we should put on the record whether or not that's permitted so that Franklin County knows whether or not that is something she can use.
OOH, okay, that comment was wild. The judge basically just roasted her in open court. And here's the problem. Medical marijuana is a real thing, but courts often treat it like it's just getting high. This is where legal systems clash with medical reality. Should a judge be allowed to talk like this? Or is that crossing the line?
Maybe that's why you don't know what the heck's going on. Maybe you're staying high all the time. So I'm not going to approve that. She's got a cannabis use disorder. How can cannabis use be recommended? So you can't smoke marijuana. If you do, you'll be back here. Anything else? Okay, that's all. Thank you.
"12 seconds later."
Be on marijuana, and it controls my pain.
Do you have a letter to that effect?
Yes, from my daughter. My medical papers. Yeah, you want the medical card the doctors gave me?
I'd like to see a letter saying that because you're diagnosed with cannabis use disorder. That's a medical diagnosis. You have a cannabis use disorder. That's what the evaluation says. So why would, if you have whatever disorder, why aggravate it with continuing to use cannabis is the question.
I have pain, sir. I died on the scene by the semi.
Do you have a letter from a physician saying that's necessary?
My daughter did all my stuff.
I mean, I'm not really sure. We sent in all her health records, but prior to her accident, it wasn't based off.
Yes.
Okay, this is your diagnosis, Ms. Bell. If you get a letter from a physician and present it to probation, something tells me you want to use medical marijuana bad enough that you'll go to that trouble. If you get a letter from a physician, a doctor, not somebody that you get online.
He was a doctor.
Well, good. Then you can get a letter from that doctor and give it to probation, and they'll ask me to change it, and I will.
All right, I'll get it today.
Thank you, Anna.
This is actually the most important legal moment so far. The judge is basically saying, I'm not saying no forever. I'm saying show me proof. And honestly, that's fair. Courts need documentation, not emotions. But here's the real issue. This woman seems mentally overwhelmed. If she can't even explain her case properly, how is she supposed to navigate medical letters, probation rules, and legal conditions?
Motion.
Sure, Your Honor.
Ms. Lewis, in cause number 24, DCCR 0766, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 30th of 2024 for the offense of aggravated assault with a deadly weapon, a second-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department January, February, March, June, July, and August of 2025. And is that true or not true? True or not true? Thank you. Count 2 alleges that you failed to provide verification of performing the community service hours as directed. Is that true or not true? Count 3 alleges that you failed to enroll in services at Spindletop as you were ordered. Is that true or not true? And then count 4. Okay. We'll talk about what happened after. So count 4 alleges that you're behind in your court-assessed fees. And is that true or not true?
He gave me opportunities.
Okay. So did you enter your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily? And did you plead true to those counts because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Is there any evidence that Ms. Lewis is not competent?
Negative.
I find those counts true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing and ask the probation department to do an updated report. That'll give me more information about you and what's been going on with your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, talk to Mr. Parker about that, and he'll present it to me on your behalf when we come back.
Now this is the cliffhanger moment. The judge technically could have revoked probation immediately, but he didn't. He delayed sentencing to get a full updated report, which means she still has a chance to save herself. But make no mistake, when sentencing comes back, it can go from second chance to jail time real quick. So what do you think? Was the judge being fair, or just postponing the inevitable?